Hi guys. Today I'm going to be speaking to you guys about something very important if you're new to Cardiff. And this is our pilot episode for the V&G Cardiff podcast. If you are looking at moving to Cardiff or anywhere in England and Wales and you're travelling from abroad or where maybe you're travelling domestically within England, if you're going to be there for a sustained period of time, you're going to want to look for a place to rent initially. Feel out the area, see how it goes, and hopefully you'll save up enough money and be able to buy your own place. But when you are looking to rent somewhere, you're going to have to enter into, more likely than not, for everything to be legal, a tenancy agreement. Now, most of these are dealt with by assured short hold tenancies. Now, I'm going to try to break it down as easily as possible for you guys and make it as entertaining as possible. No complicated legal jargon, just straightforward, and hopefully this will help you let you know a little bit more about what you're signing into. So, first and foremost, an assured short hold tenancy is more likely than not what your landlord would provide you with. Now, this could be a minimum period of 6 months. It can be for 12 months. And after that term has ended, as long as everything is going well, you're happy at the property, the landlord's happy with the property, the state of the property, rent's being paid on time, there's no issues about disrepair, then it will just fall into a rolling tenancy whereby it just carries on going on a month to month basis. But just to make it clear, they're normally for a period of a minimum of 6 months, and then they go on from there. You've got to remember, guys, that when you sign into this agreement, you're signing into a legally binding contract, which means you're contracting, so you're promising that landlord that you will pay that rent for that amount of time on the date that he says as well, and obviously the date that you have agreed, and you agree to your obligations, so your duties as a tenant, i.e. to keep the property in a good state, to make sure that you pay your rent on time, to not have any issues regarding antisocial behaviour, i.e. having a crazy party 3 o'clock in the morning, on early hours of a Wednesday morning, and disturbing all your neighbours who are trying to get some sleep so they can go to work the next morning. That's what you want to make sure that you adhere to as a tenant. But on the flip side, the landlord has to make sure he provides you with all the prescribed information, particularly if you're renting a property in England. But obviously, if it's in Wales, there's specific prescribed information that needs to be provided with the tenancy agreement. And of course, if you are paying a deposit is normally an amount of money you're paid upfront to the landlord on top of the rent to cover any issues that might arise at the end of the tenancy, i.e. disrepair, keeping the property in a poor state, so on and so forth. Now, this deposit, you need to make sure that you have a copy of this as well, but this deposit needs to be protected in a tenancy deposit scheme. It needs to be with an authorised scheme, and the landlord has to protect the deposit, within a period of 30 days from the beginning of the tenancy. So you should receive a tenancy deposit certificate within 30 days of receiving or signing into your assured short hold tenancy. Could be sent to you by email, but sometimes they're also sent to you as a paper document. And I'll say TDS or whatever the scheme is, give you a tenancy deposit number. And of course, at the end of your tenancy, whenever you decide to leave, maybe you've saved up enough money and you found your own new bachelor pad or your own bachelorette pad that you're going to pay for out of your own money, and then obviously live in on a mortgage or whatever, then as long as the property that you are renting is all fine and dandy, the landlord's happy with it, that deposit would be returned to you anyway. We just want to make sure that, of course, that deposit is protected. One other thing that you want to look out for is any break clauses within the assured short hold tenancy agreements. So, for example, if your agreement is for a year and the agreement states that after a period of 6 months, either party can give the other party 2 months' notice and end the tenancy agreement early, you just need to keep an eye out for that, because obviously your landlord, they are legally able to give you notice if there was a break clause. For example, after 6 months, they can give you 2 months' notice, and then they can effectively apply to have you evicted from the property 8 months into a 12-month tenancy. So, of course, you've just got to make sure of all of the minor issues that may appear minor, should I say, but they can have major impact on your tenancy agreement. So you just want to make sure that you read the agreement, know what you're signing into. Any issues, you can always consult Citizens Advice Bureau. There's loads of great free advice services within the UK. Shelter as well may well assist you. And of course, there is the free representation unit, also commonly referred to as FRU, that do sit in a lot of courts that may be able to help you with this, along with the PSU, the Personal Support Unit as well. But look, failing all else, you can always go to Citizens Advice, go and nag them a bit, and ask them to explain any points of your tenancy that you're having trouble with. Just one quick heads up, all I'd say is make sure you know what you're signing into, and make sure that you are aware exactly of the terms and conditions of the agreement. We all love reading paperwork, I know, but it's just important to make sure that you pick out the important points, just so you don't have any nasty surprises going down the line. Now, just one other thing as well, whilst you're moving in, the landlord may want to carry out an inventory, particularly if you're going into a furnished property. So there's sort of two sorts of main agreements. There'll be a furnished one whereby everything's included, tables, chairs, so on and so forth, microwaves, TV, desks, and all of that good stuff. But maybe if you've got all of your own furniture, you may well prefer to go into an unfurnished property, which means it's all completely like a blank canvas, so you can add your own furniture, put it where you want to, and decorate the house as though it was essentially your own. In terms of moving into the property, you just want to make sure that if it is furnished, your landlord's carried out an inventory. So, for example, if there's any issues with the cooker, if there's a button or a knob missing, it's just noted. That way, when you do move out of the property, you've got nobody turning around and saying to you, Mr. Smith, where is the two buttons that were missing on the cooker, or where's the plug socket safety covering or something like that. And you don't want to get these sort of issues, because effectively it can end up in you having to pay sums of money out of your deposit potentially, or you having to pay some sums for an individual to come down and fix or amend any damage which is deemed to have been caused by you. So if you've got that inventory in place, if the landlord has, it just protects all parties and make sure that everybody's clear right from the outset. Then, just on the flip side, I'm going to talk to you a little bit about the end of a tenancy, what happens if you fail to pay your rent, what happens if the landlord wants you out of the property, and the relevant legal procedures that would need to be followed. And we're going to go through that right after this short break. I'll play a nice chilled out song so you can be nice and relaxed when we get to all of that entertaining stuff about evictions. See you in a bit, guys. Thank you. Okay, guys. Well, welcome back. Hope you enjoyed that short break. Maybe you've made yourself a nice cup of tea, and you were happy listening to the soothing sounds that were playing during the break. Right, let's get on to something a little bit less soothing now. Um, Potential evictions from a property or an end of a tenancy agreement. Now, look, just one heads up, if you are struggling to pay your rent, maybe you've had an issue with your job, maybe there's an emergency that's popped up and you need money for that, try to speak to your landlord. Don't just bury your head in the sand like an ostrich and stick it there, because what will happen is the arrears will build up, the landlord will then have to take it to court, and you could potentially be evicted and then have to, be mandatorily removed from a property, and then you could be potentially homeless or have to go to social housing, and you want to avoid that at all costs. So, first and foremost, one thing, a very, very salient point I'd say is, if you're struggling with your rent, have a chat with your landlord. Maybe you can agree to go on a half rent for a month or two, and then potentially repay that arrears bit by bit. There's also some other agreements that you could enter into. Maybe have 1 month off or 2 months off the rent, and then make it up. But what I would say is, don't just ignore the issue. Ignoring the issue, it won't go away, and it's just going to make things much more difficult for you afterwards. Now, if for whatever reason you're unable to pay the rent, or in the alternative, the landlord just wants access to his property, maybe he's, wants to move into the property, maybe he wants to carry out some works, maybe he wants to, do the property up, or there's some major repairs that are needed, that it's unsafe for you to remain at the property while these are being carried out. He can serve 2 different sorts of notices on you. Now, I'll just deal with these separately because I don't want to confuse the heck out of you. They're confusing enough for me as it is. So let's deal first of all with Section 8 notices. Now, Section 8 notices are served because of issues that are allegedly the fault of the tenant. So if you're staying at the property, of course, the landlord's effectively saying these are your issues, and of course, if you're the landlord, you're serving a Section 8 notice because you're basically stating that the tenant hasn't complied with the terms and conditions of the assured short-hold tenancy. This could be due to rent arrears, or this could be due to antisocial behaviour, if you smash the place up, God forbid, but certainly these are clear breaches of the assured short-hold tenancy. Now, most of these are brought under Section 8 because of rent arrears. Just to bear in mind, the amount of arrears the amount of months that a tenant needs to be in arrears for the matter to go to court, so to be deemed worthy for litigation, are 2 months. So if you can keep your rental arrears below 2 months and maybe reach some sort of agreement with the landlord's not able to take the matter to court as long as the arrears are below 2 months. 2, that's the magic number, not 3 on this occasion, 2 months. Now, if for whatever reason you're struggling and the landlord is not able to reach any agreement with you, or you're not able to make any payment plan, and your arrears are over 2 months, the landlord then needs to serve you with a valid Section 8 notice. Now, this notice needs to, for example, have your name spelt correctly, state clearly what the reason is for, the reason why you're seeking possession of its property, and the landlord has 1 year to apply from the date of this notice for court action. Now, for example, if the Section 8 notice is served to you on the 2nd of January 2022, the landlord has 1 year from this date to apply for court action. If he doesn't apply for court action, then that Section 8 notice becomes invalid and he will have to serve a new notice and reapply again. Now, I'm just going to raise a few points regarding the dates, because dates are important, particularly with the coronavirus. I mean, look, People are dropping like flies at the moment, and I always think that if you've got your health, everything else is a bonus. But because of the current pandemic, you need to make sure that you are aware of something with regard to these dates. So, firstly, if the Section 8 notice was served on you previously between the 29th of August 2020 and the 31st of May 2021, and you've got less than 6 months worth of arrears, then you have 6 months from the date of the notice to leave the property. However, if the Section 8 notice is served between the dates of the 29th of August 2020 and the 31st of May 2021, and you've got more than 6 months worth of arrears, you've only got 4 weeks notice. So you've got 4 weeks then from which to leave the property. And just to keep in mind, guys, if the matter does go to court and you are effectively if you do have a possession order made against you, only bailiffs, court-appointed bailiffs, can come and evict you. Joe Bloggs down the street can't come and evict you. Now, just in terms of these dates with the arrears, if the Section 8 notice was served to you on or after the 1st of June 2021, that's on or after the 1st of June 2021, and you've got less than 4 months arrears, you have then 4 months notice, so 4 months from which to leave the property before the bailiffs get involved, and it gets a bit, well, it gets very, very difficult from there. However, just a very, very important point to bear in mind, if the Section 8 notice is served on you on or after the 1st of June 2021, and you've got more than 4 months worth of arrears, so over 4 months of arrears, you've only got 4 weeks to leave the property. Pre-pandemic, it was 2 months notice, and that was it. And then obviously the landlord could seek court enforcement. But that's just a few points regarding the dates. You might want to just jot that down, keep that in the back of your head, in case the notices were served at that time. Now, I hope those points help you with Section 8. I'm just going to briefly discuss Section 21. Section 21, they're considered non-fault evictions. Now, these are issues whereby it could be the landlord just wants his property back because like I said, he wants to carry out repairs. And I'm going to go into those eviction details and some important points you need to know about the evictions and the notices, how they should be served on you right after this break. See you soon, guys. Okay, guys, welcome back. Final segment. Now, I hope you enjoyed the tune that was played, and I hope you're ready for the last part, Section 21 notices. Oh, the joys of Section 21. Right. So a Section 21 notice, like I said earlier, is a non-fault eviction. For example, the landlord wants his property back, and a Section 21 notice must be made after the first 4 months of the tenancy. So after 1 month of a tenancy, a Section 21 notice can't be served. After 2 months, Section 21 notice can't be served. It needs to be after 4 months. And this must be done in writing on the valid form. Now, it's a Form 6A, for example, and that's for any agreements after the 1st of October 2015. So any short hold tenancy, AST, entered into after the 1st of October 2015, Section 21 notices must be served after 4 months on a Form 6A. It's got to be valid, your name must be spelled correctly, it must state the reason for the eviction, i.e., disrepair issues or something like that. It needs to be clear. Any problems with this, if we don't understand it, get down to your nearest Citizens Advice Bureau. Get down there as soon as you can, guys. Find out what the crack is with this and make sure that your notice is valid. You can also speak to Shelter Cymru if you're in Wales, or you can speak to Shelter if you're in England. There's no Cymru on there for obvious reasons. Now, the Section 21 must give you at least 2 months' notice, But of course, there's some very important dates with the notices in line with the coronavirus restrictions. So I'll just deal with these points now because it's important for notice. Normally, 2 months' notice would be provided, and if the Section 21 notice has been served on you between the 29th of August 2020 and the 31st of May 2021, you've got 6 months' notice. So the landlord has to wait 6 months before issuing a court notice. And of course, that's a very important point to bear in mind. 29th of August 2020 to the 31st of May 2021, you've got 6 months' notice. Any Section 21 notice is served on or after 1st of June 2021, you've got 4 months' notice. So you've got effectively 2 months less. But the landlord can apply for court proceedings after 4 months. So just keep those dates in mind. Now, obviously, in an ideal world, with a Section 21 notice is served, and for example, you've got 2 months' notice, the landlord would want you to find a new place and move into the new place within that 2-month period. If you're having problems or there's an issue with that and your rent's still being paid on time, speak to your landlord. I'm sure most landlords will be more than happy to have an extension of that notice period. They'll save you money, save them money, save you time, save them time, and save everybody a lot of heart and headache. So have a chat with them. Now, if you can't agree something and you need to stay after the notice period, so for example, if the notice period was 2 months and it was valid, the landlord can then apply to take them out to court proceedings. If he doesn't apply to take the matter to court proceedings within the time set out within the Section 21 notice, that Section 21 notice becomes invalid, and if he wants to take them out to court, he'll need to re-serve you again. Now, if you do get a Section 21, as I said, make sure your deposit has been protected within an approved scheme within that 30-day period, because if your deposit hasn't been protected within that 30-day period, you can effectively make an application that Section 21 notice isn't valid, and you can ask for that deposit to be paid back to you. Also, with the Section 21 notice, the landlord has to provide you with up-to-date copies of the following: gas safety certificate, if you can get an engineer to get access to the property, the energy performance certificate, and how to rent guide. Now, these are important documents. So a Section 21, just a point to note, Section 21 isn't valid unless you've got up-to-date copies of the gas safety certificate provided with it, the energy performance certificate, and the how to rent guide. Now, one other very important point to make you guys aware of: if the council, so your local council, whether that be Cardiff County Council, the council in Bristol, wherever you're based, has sent your landlord what's termed as an improvement notice or an emergency works notice, the landlord cannot serve you with a valid Section 21 notice. So if the landlord's been sent an improvement notice or an emergency works notice, he can't serve you with a valid Section 21 notice. And then just a final point, guys, if it does go down the eviction route and they have bailiffs involved, the bailiffs need to be High Court enforcement officers or High Court bailiffs or County Court bailiffs. Only these guys can evict you. No one else. If you are experiencing symptoms of COVID, you need to tell the bailiffs, and those bailiffs then will have to make other arrangements, and the eviction could well be rescheduled for another 14 days after. So if the bailiffs, if you are suffering from any COVID symptoms and you have an eviction impending, tell the bailiffs as soon as possible. They will then need to reschedule that eviction. And one other point, I hope it never ever comes to this, but if you do have a possession order against you, before it gets nasty and the bailiffs get involved, if you've got young children or health issues, if you go to most local councils with an order for possession made against you, you'll be put on the priority list for social housing, which shoots you right up the top of the list. You will then be able to access priority council accommodation, hopefully. Anyway, let's hope you don't have to go down that route and you get a nice 6 or 12 month AST. You pay your rent on time, the property's great, you've got your heating and your hot water, TV's looking fantastic that you put on the wall, and maybe the landlord's splashed out a little bit and he's got a fish tank built in the wall as well. I hope that goes well for you, but you just need to be aware of the rules regarding that. And I'll be back with some more information as to the process regarding tenancy and the court procedure. Don't forget, guys, hit that like, subscribe, whatever you need to do. And I hope you have a good day. Take care. Bye-bye.